Welcome to a sequential 10-section forensic audit of Rule 21 of the Rules of Court. This audit maps the specific procedural requirements the state must follow to compel the production of evidence. Section 1 defines the subpoena as a coercive legal process. It is a direct command from the state to a specific person, requiring them to either physically attend a proceeding or produce tangible evidence under their control. The general rule of compulsion is strict. A person cannot be forced to testify unless they have been validly served with this process. There is exactly one exception to this rule of prior service. If a person is already physically present in court before a judicial officer, the court can require them to testify as if they were attending upon a subpoena. This logic tree splits into two distinct legal functions. If the court requires a person to attend and testify, it issues a subpoena ad testificandum. If the court requires a person to bring documents or other things under their control, it issues a subpoena ducis tecum. Practitioners must distinguish this from a summons. A common error in analyzing fact patterns is treating the two interchangeably. They execute entirely different legal functions. A summons establishes the court's jurisdiction over the person of the defendant to initiate the suit. The subpoena is the singular tool that establishes the court's control over the evidence required to decide it. Moving to Section 2, we determine who actually wields this power. The authority to issue a subpoena follows the specific locus of the trial or the investigation. While the court hearing the case is the primary issuer, it is not the only one. The court where a deposition is taken, or authorized investigative bodies like the National Bureau of Investigation or the Office of the Ombudsman, seen here, also possess direct subpoena powers. However, this power has an absolute limit regarding a specific class of witnesses. Prisoners sentenced to death, reclusion perpetua, or life imprisonment cannot be brought outside a penal institution by a standard subpoena. A standard trial judge lacks the authority to extract these inmates for a court appearance. An ordinary court order attempting to do so is legally void. Extracting these specific maximum security prisoners for court attendance absolutely requires authorization from the Supreme Court. No other judicial authority can override this convict restriction. The power to compel evidence is expansive, but it immediately yields to the state's interest in securing individuals already serving the most severe penal sentences. Section 3 dictates the exact form of the demand. Procedural due process requires strict, granular specificity in the subpoena's text to properly inform the witness of their obligations. Every subpoena must state the name of the court and the title of the action. For a subpoena ducis tecum, the items must be reasonably described and must appear to the court as prima facie relevant to the case. Broad demands for any and all corporate records are structurally invalid. These fishing expeditions fail the requirement of reasonable description and can be challenged immediately. When a demand is invalid or overreaching, Section 4 provides the legal defense mechanism, the motion to quash. The grounds for quashing vary. A ducis tecum is quashed if unreasonable or irrelevant. An ad testificandum is quashed if the witness isn't legally bound to testify. Universally, both are voidable if the requesting party fails to tender witness fees and kilometrage at service. Note that filing a motion to dismiss to challenge a subpoena is a fatal procedural error. The motion to quash is the specific remedy for attacking the process itself. A witness has no legal obligation to comply with a subpoena that lacks textual precision or fails to provide the mandatory tender of financial costs. Section 5 governs subpoenas for depositions, connecting the pretrial discovery mechanics of Rule 23 with the compulsion rules of Rule 21. Serving a notice of deposition allows the clerk of court to issue a standard subpoena. However, the clerk is prohibited from issuing a subpoena ducis tecum for a deposition without a specific order from the judge. Moving to Section 6, the rules of service ensure the witness receives actual notice and the physical funds required for travel. Subpoena service strictly mirrors the personal and substituted service hierarchy found in Rule 14 summons. It requires either handing the copy directly to the person or leaving it at their residence or office with a person of sufficient discretion. This creates the email subpoena trap. The 2019 e-service rules don't generally apply. Because service requires physical tender of witness fees and kilometrage, standard electronic service is legally impossible without specific court intervention. Finally, Section 7 establishes that physical presence in the courtroom waives the necessity of formal process. A person already in the court's presence can be compelled to testify without prior service. Whether through physical tender of costs at a residence or through physical presence before a judge, the court's power to compel depends entirely on physical proximity to the witness. Section 8 of the rules governs the kinetic enforcement of the court's command when a witness defies a valid subpoena. If a witness fails to attend without just excuse, the court may issue a bench warrant. This authorizes the sheriff to arrest the witness and physically bring them before the court or officer where their attendance is required. Distinguish this from a criminal arrest warrant. A civil bench warrant is not a penal charge. It is a coercive tool used exclusively to compel the witness to perform their duty to testify. Section 9 introduces further punitive sanctions. Defying a subpoena without adequate cause is deemed a defiance of the judicial system itself. Willful disobedience constitutes indirect contempt of court. This requires a formal charge and a hearing before the court can impose fines or imprisonment. Ignoring a valid subpoena marks the ultimate transition from standard civil procedure into a state-sanctioned deprivation of personal liberty. This power is not absolute. Section 10 establishes a hard geographical boundary on the court's ability to compel witnesses in civil cases. This is the viatory right, or the 100-kilometer rule. Witnesses residing over 100 kilometers from the trial cannot be compelled to attend through arrest. For them, the litigator's only remedy is traveling to take their deposition under Rule 23. Note that the viatory right applies only to civil cases. In criminal matters, the state's right to prosecute overrides this 100-kilometer boundary. Rule 21 relies on mechanical triggers. First, the correct form, second, a valid service, and the mandatory tender of costs. Pendiz wine, the court possesses the power to seize both evidence and individuals. Success in any civil litigation requires knowing exactly when the court holds the absolute power to compel a witness, and exactly when the witness holds the protective shield of the law.